The key purpose of a patent is to allow the owner of the patent to control the use and commercial exploitation of the invention during the patent period. A patent provides exclusive rights to a patentee to make, use, or exploit an invention and to authorize others to exploit that invention. A person will directly infringe a patent under Section 13 of the Patents Act if they exercise any of these exclusive rights without the authority of the patentee. But what does the key word exploit actually mean? Schedule 1 of the Act provides us with a definition, which is to make, hire, sell, or otherwise dispose of a product, or to offer to do any of these things, to use, import the product, or to keep it for the purpose of doing any of these things. The question of whether an invention has been exploited is a question of fact which needs to be determined by reference to the claims of the patent. In order to determine whether an infringement has occurred, firstly, we must analyze what the patent claims or specifications are, and secondly, compare the alleged infringement activity with these patent claims. The first step requires us to interpret the patent specifications to establish the boundaries of the patentee's exclusive rights. The modern approach to interpreting specifications is the purposive approach, which gives effect to what a person skilled in the art would have understood the patentee to be claiming. Basically, this approach is used to determine what the essential integers of a claim are. The next step is to see whether the alleged infringing item falls within the construed claims. We will now go through the various situations in which an infringement of a patent will occur. A person will infringe a patent if they make the invention for any commercial purpose. The term make is interpreted contextually. The established view is that a product is made only when all the essential integers from the claim are included. Furthermore, to be an infringement, the whole of the patented product must be manufactured, not just the constituent parts. There will also be an infringement if a patented process is exercised. Even the products that result from the use of this process are covered under the patent. If a person makes the patented product as an intermediate step in the manufacturing process, but includes additional features to it which are not included in the patent claim, such that the final product is different from the patented product, this will still be an infringement even if the end result is a non-infringing product. A person will infringe a patent if they exercise the exclusive right of the patentee to hire, sell, or otherwise dispose of a product in any commercial sense. Although the mere possession, purchase, ownership, or transportation of a patented item will not of itself suffice to be an infringement, if there is an intention to trade the product at present or some time in the future, then this will be an infringement. If the patented product is used without authority, this may also be an infringement. However, it will only be an infringement if it is used in a manner that is consistent with the inventive nature of the product. If the product is used in such a manner, then there will be an infringement even if the user had no intention of selling the product. If a patented process was used in any commercial sense, then this will also be an infringement, and this rule extends to products that are created from using such patented processes. However, the contribution of the process to the creation of the final product must be an important step in the manufacturing process and not a trivial one in order for there to be an infringement. The other form of infringement besides direct infringement is contributory infringement. Section 117 of the Patents Act provides the requirements for contributory infringement. This means that a party may be liable where they enable another party to infringe a patent. This can happen where a party supplies a product which they know the buyers will use to infringe a patent. For example, in the case of Northern Territory and Collins, the government granted a license to a company which allowed them to access land containing cypress pine trees and to harvest the timber. The company used that harvested timber to produce the patented cypress pine oil. It was found that the granting of the license was sufficient to constitute a supply under the Act, which enabled the infringement to occur.